and gentlemen, you're watching News Now with me, Sumita, Kareer, and our top story tonight. Well, the Ministry of Electronics and Information Technology last night released draft rules under the Digital Personal Data Protection Act 2023. It has even sought public comments till February 18th, so that's the deadline by which public stakeholders will be able to share their feedback, their comments on these rules. Now, these draft rules will deal with the provisions of personal data breach, protecting children's data, consent manager framework, and how data transfers are to be managed beyond a specific geography. Now, these rules provide an exhaustive list of guidelines that organizations must follow under several different categories. For instance, user consent is going to be mandatory for organizations who will be processing data of individuals. Users can also revoke the consent given to these data fiduciaries. In case of a data breach, its data fiduciaries will be held accountable, and they must inform users about the breach that has occurred without any delay, and they should also undertake mitigation measures. There are also rules then with respect to what happens in case of disbursal of state subsidies or benefits. In fact, in cases of national interest, sovereignty and integrity, central government is empowered to call information of users. It can even restrict the transfer of personal data of users to other specific countries or geographies. And most importantly, ladies and gentlemen, the very contentious issue of children's privacy and safety on online platforms has now been taken care of. It is now parental consent that will be needed for corporations to process children's data. But the big question is, are these rules enough to guarantee a user complete right over his privacy and data, even as we're living in an increasingly online and connected world? And do these rules balance power given to the state and that which is given to individuals? To discuss some of these issues and many other issues related to these rules and, of course, the DPDP Act 2023, I'm now joined by N.S. Nappinai, Senior Advocate, Supreme Court, and, of course, Dhruv Suri, Partner at PSA Legal Counselors. Thanks very much, Dhruv and Ms. Nappinai, for joining us here on ET Now. Let me come to you first, Mr. Nappinai. Now, there have been concerns about how privacy is exactly in an individual's personal data and complete control of a user over his data. But do these rules that have been published last night by the Ministry of Information and Technology really take care of that concern, which has been held for far too long now?
One, I would say that the new year brings cheer that finally we have got the first look of the rules. So hopefully the light at the end of the tunnel is almost there, right? So we will soon get our DPDP Act implemented. So that's the hope we live in. Whether this is enough or not is something that's always going to be answered in the negative because, you know, this is work in progress. I don't expect it to be a catch-all. Even the DPDP Act, if you see, was minimalist and we expected a lot more from the rules to come in. My biggest concern when we are talking about individual privacy, and I have been batting for this for many years now, which is that Indian citizens should be treated on par with the EU citizens. That we should be given an opt-out and the right to have that opt-out without losing the service is a criticality that should be addressed within the Act itself. The Act obliquely, at least that's what the ministry claimed, obliquely adverted to this, and we expected clarity through the rules, and I personally feel that is missing sadly from the draft we have.
Okay, Ms. Nappinai, let me take that question over to Dhruv. Dhruv, if you've gone through the exhaustive list of rules that has been really published and it really touches upon the various aspects that I was mentioning during the start of the show, do you think these are comprehensive? Do you think there has been enough clarification? Because that was one concern that was raised in 2023 when the DPDP Act was passed in Parliament. And most importantly, the other point that has been raised by Ms. Nappinai, how do these rules compare to European Union's GDPR, for instance?
Thanks. So, look, I think if we approach the rules from a mindset that we want a perfect document that is going to be flawless, I don't think that's the right way to look at it. The point is that this was light at the end of the tunnel. We were all looking for rules. The act in itself that we got is a very principle-based act. The government has intentionally ensured that it's not very heavy on compliance, not very heavy on a lot of procedural aspects. They've given a lot of discretion to what we call in the rules the data fiduciaries, people who will really be taking decisions and calls on how and how data needs to be processed and the basis of processing. So I think the rules are essentially a great step in that direction. Are they perfect? No, they are not. Can they be improved over time? Most certainly. But I do think if you think of it from an industry perspective at this point of time, would industry be completely left in the dark with no rules? Or would it have some rules so that there is some direction in which it can start working? I think these rules certainly give us that direction on the basis on which then blocks can be built as we take this law forward.
Absolutely, Dhruv, and this is an important piece of legislation which really defines privacy and rights of individuals while also laying down a framework for organizations and how do they really function. Of course, you said that this is not really perfect, but at least, a simplified set of rules has been put in place, for data privacy rules to be followed. And we'll touch upon some of those aspects that it lacks. But let me come to you, Ms. Nappinai. Now, when we speak of privacy and rights, it is really the K.S. Puttaswamy judgment that really is the benchmark. Now, do these provisions meet those constitutional requirements that have been outlined in the K.S. Puttaswamy judgment?
Substantially, and we are really not looking at the rules for implementation of the Puttaswamy judgment. The Act does that. So the rules only follow what the Act has already laid down, and it is only supposed to set out the modalities. So when we talk about whether the rules are sufficient or not, it's more in terms of the clarity that we expected to come for the fundamental provisions that are already part of the Act. So just to clarify with respect to the Puttaswamy judgment also, privacy was a fundamental right before and after the Puttaswamy judgment. It wasn't from the Puttaswamy judgment that we got this fundamental right. Puttaswamy just affirmed this right with us. It laid down the necessity for a law to be in place to ensure that our rights are protected in an appropriate manner. We have already heard a lot of concerns with respect to the Act, particularly in the context of exemptions. On that front, I personally feel that the exemptions are in line with what you would find in GDPR also. You cannot have a DPDP Act without certain exemptions being built in, which will allow for instance, governance,
Absolutely.
for medical aid, for educational institutions to function, for employers to exercise their rights, etc. So these exemptions by themselves do not cause any harm. The modalities in terms of how it will be implemented is what we'll have to wait and see. A lot of the rules, if you look at what it actually covers, you should just do a search of the word prescribed in the DPDP Act. You'll see how often it is used. Dhruv was mentioning about it being a principle-based act. All acts are meant to be, specific because rules are only meant to be the modalities for implementing the act. You cannot have a policy-based act and then the rules.
Absolutely, and these are just some set of directions.
Exactly. So when you look at the way...
Yes, these are just giving a certain set of directions for the implementation of the Act.
Yeah. So a lot of things which you would expect, like, clarification on the notice for consent, for setting up the board, how an appeal is to be filed, etc., are something that's par for the course. The additional clarification we wanted and that ought to have been there is missing in some parts. That's what I wanted to emphasize.
Okay. Do you want to, Dhruv, I'll come to you in just a bit, but Ms. Nappinai, could you please list down those, certain things that you feel that are missing and perhaps more clarification is needed from the ministry and, of course, the government?
Child rights, you mentioned that in your opening statement. And I think that's a very critical issue, which we actually expected a lot more from the rules in terms of possibly laying down certain specific modalities on how parental consent is to be ensured. But if you look at what the rules are doing now, it effectively leaves it to the platforms to decide. And it also lays down certain exemptions. And on that front, I actually must clarify that I had a lot of concerns about the third part of the child rights in the DPDP Act, which gave the central government the power to exempt under rules. I would say that the rules have exercised that right in a very cautious manner, and to that extent, that's fair. But some further clarity in terms of what is the technology or law based protection that the platforms have to exercise to ensure actual parental consent, which cannot be circumvented easily, because we have to remember that humans are always still smarter than machines. Every protection you put in, we'll find two ways to circumvent it. So we need to have certain guidelines laid down.
Right.
Similarly, I already mentioned about the opt-out part of it. But moving forward, you now have a bit of a surprise thrown in with respect to data localization. And the rules do not give you clarity on what the data localization is going to be mandated. It still leaves it open-ended for central government to decide a category, and then they tell you what is it that should be localized in terms of personal data as well as traffic data. So similarly, when you move forward in terms of
so clarification on that.
Yeah, just one last point on penalties. Everybody, there was a misconception which I read in news items about how the rules don't address it. I fail to understand why the rules have to address it. The Act addresses it, and that's more than sufficient. But where I expected clarity was on whether the data principal, the victim, will get compensation, and the rules are silent on that.
Very valid points, ma'am, you're making about, victims actually getting compensation. And to the point about penalty, of course, it's been mentioned in the Act about, penalty could reach up to 250 crores in case of violations. But let me also take the points that you've mentioned, take them across to Dhruv. Dhruv, on the point of parental consent that is needed in case of children's data, if companies need to access that. Now, ma'am is saying that it gives data fiduciaries too much power, but the rules also mention that data fiduciaries have to ensure that the guardian, in case of children, has to be court appointed.
Yeah, I mean, so look, the guardian concept, the way it's been used in the rules is slightly different. It's used more in the context of people with disabilities, even though the Act very clearly clarifies that a parent and will include a legal guardian even as far as a child is concerned. But I think what the parental consent requirement has really sort of done in the rules has taken it one notch above in terms of compliance, where now companies have to ensure that they take verifiable consent of the parent before they can start processing data of a child. And I think this essentially, from a compliance perspective, if you think of a social media company, you think of an ed tech company, it really sort of puts that additional burden on them to ensure that they can actually verify that the parent is an identifiable person who is giving consent on behalf of that child to be able to process that child's data. Right. So I think so so of course, from a compliance perspective, this is going to be a bit of a challenge for companies. If you and sort of going back to the point that ma'am was making about even penalties, right? When you think of there is no compensation payable to the data principal as such. While that's absolutely true, and I think what's really interesting in this law is actually a provision for mediation. I don't know, ma'am, if you've had a chance to look at that. The mediation provision is actually talking about a scenario where if the Data Protection Board believes that some dispute or some issue that's being adjudicated by it can be decided outside the board in a mediation, then it may direct the parties, which could include a data principal as well as the data fiduciary, to go outside and settle the matter. So it's only anybody's guess at this point of time how this mediation proceedings will be used, and if it's likely to become some sort of a mechanism for data principals, for aggrieved parties to perhaps negotiate some sort of a settlement as part of a mediated proceeding.
Right. Right, Dhruv, and we do expect some clarification, further clarification from government so far as this mediation aspect is concerned, because I remember when the act was passed, the government did mention that, of course, as far as implementation is concerned, there will be more compliance, there will be more responsibility on, bigger companies, bigger corporates to implement it first, and then startups will be, taken through that whole process of implementing these rules. But let me ask you, Dhruv, one more question before I go to Ma'am Nappinai. Now, Dhruv, how do you think smaller companies and startups will immediately be looking at implementation of these rules? And what are you expecting from governments so far as operationalizing these rules are concerned? And what kind of timelines and timeframes are you, for instance, looking at proposing for effective implementation of these rules?
So look, at this point of time, what's very clear is that, post this consultation process, the provisions that will get triggered first are, to set up the data protection board, to hire the chairman and its members. And it's typically the process that's followed under most legislations. And once that is done, is when the more substantive provisions of the law will start getting notified. In terms of timeline, I would imagine that the board is likely to get set up maybe towards the later part of the year, around October, November, depending upon how things go. But the more substantive provisions of the law, I would imagine, are likely to only come into force from next year. As far as startups are concerned, as far as companies are concerned, if you look at the kinds of compliances that they have to do, they have to ensure reasonable security practices. They have to ensure that they are keeping track of what all data they are processing to be able to implement data subject rights. One thing is clear, that if you want to comply with privacy regulations in India, it's not just going to be a legal problem or a technical problem or a security problem. It will be something that will have to be dealt by all these verticals or any vertical rather in an organization that manages and deals with data. And technology products that companies will need to start evaluating, start taking demos of, to be able to comply with this privacy law. Even when we look at GDPR, when GDPR came out in EU, a lot of these product companies essentially came and helped with compliance. And I don't think India is going to be any different. So even startups will need to start evaluating tools, products that they can adopt and use them to then comply with the consent requirements, the
Right.
data subject requirements, etc.
Right. Right, Dhruv, very interesting points that you've made, but let me come to you, ma'am. Now, these rules present two very interesting points with respect to how the state is involved and how much control does the state have. Number one is on how data is to be shared in case of disbursal of government schemes and subsidies. And the number two point is in case of national security and how data then will be used by government. In both of these cases, do you think the government balances individual rights and privacy and how data sharing is to be handled?
Yes, and there are certain aspects with respect to the rules on, the state handling data, which I was actually a little relieved to read. Because, you will see that there has been a couple of instances where data that has been provided to the state in its functionality as a state, as in governance role, has been sold for private usage or consumption. Now, when you look at the rules, it very clearly restricts that kind of usage of data collected for governance purpose. Because it clearly says that if you're collecting it, for instance, for issuing a license, then it will be used for that purpose only. So therefore, that purpose limitation is something that I feel gives a lot of support for data protection when it comes to the state. We have to understand the distinction between the state acting as a governance functionary and in a business perspective. So it cannot start converting that which it does as a governance mechanism into a business proposition.
Absolutely, and there are very clear and specific guidelines so far as those rules are concerned. And ma'am, one final question. I want to ask you about making data fiduciaries accountable. And of course, there is an exhaustive list that's been mentioned on how data fiduciaries will, of course, be communicating very clearly and in a very transparent manner to individuals in case of a data breach to Data Protection Board as well. How do you think the law and these rules really fare so far as putting accountability on data fiduciaries and companies is concerned?
The Act itself actually provided us a lot of support in that. The two things that the Data Protection Act actually dealt with was it did not, early days when we used to debate this, the issue was about whether it should be a consent framework or an accountability framework. And we all knew that always it had to be a hybrid of both. And that's what the Act as well as the rules have brought into effect. I would say that one aspect that everyone should be happy about is that the responsibility and duties that have been placed on data fiduciaries remain strengthened both with the Act as well as with the rules. So I would not say that in any manner the rules have in some way diluted the provisions of the Act. It has supported it and maybe buttressed it. How far it will be effective and to what extent will we have to relook the rules or the Act itself, only time will tell. And on this note, there is one tiny aspect I wanted to specifically mention also. There was a very shocking exemption that was given in Section 3 of the Act that, if you post on social media, then that will not carry data protection. That was something which was a surprise because that's not how we look at personal data protection. Now, on that aspect, when you look at the rules and read it together with the law, it comes out very clearly that every platform is still responsible and liable to protect the personal data of individual users of the platform to the extent that this is data that is submitted to the platform. The exemption from the Act is only with respect to whatever information a user may share on the platform with the public. So that delineation, I feel, is a criticality that's come out, and we have to hope that it will be well implemented. There is also a provision for impact assessment audit, etc., for significant social media intermediaries. So these are all things that have been built in, but on these aspects, I think only time will tell. And again, when we talk about time, there is one thing I wanted to kind of clarify. Dhruv seems to be very optimistic in terms of how much time people are going to have to implement the law. I'm hoping for a much shorter timeline. The fact that the public consultation is to end in February means that by June or earlier, we should be able to see the light at the end of the tunnel for the rules, which means that there may be only a 6-month window for the substantive aspects of the rules to come into effect for platforms to comply with. So I'm hoping for a much shorter timeline. We are already much delayed in terms of having our own data protection law. So let's hope that it's not next year, but in this year itself that we'll see the finality in terms of implementation.
Absolutely, ma'am. And this is something that all of us are also expecting, given the time that, of course, it has taken for these rules to come out. And perhaps rightly so, because there was that much deliberation that was needed. One final question from you, Dhruv, and we're completely out of time. On the point about age verification, now, instead of self-declarations that it could that could have the potential for mass surveillance. This has been expressed by some that age verification could lead to a potential for mass surveillance. Do you agree with that point?
Look, I don't necessarily agree with that. And age verification, age gating has been a problem that almost all jurisdictions that have tried to implement privacy regulations have had to deal with. And today the government has proposed solutions around it. It could, possibly be through the DigiLocker mechanism where your identity is already stored, your identity documents are already stored, through the process of tokenization where your identity can be stored in a vault, and that token can be used to verify your identity. So there are technical solutions that in sort of passing have been referred to in the rules. And I think, which is where the original point that I was making, that you will see a lot of people giving solutions to these problems, third-party technology companies that will make tools, that will make products to solve exactly all of this for companies to be able to do age verification in a very, very seamless manner. But in order
Absolutely.
to process children's data, I think that step of age verification to know whether the person on the other side is a child or not, and now to also be able to then verify that the parent is actually a parent or not, and to be able to identify that parent should that need be. I think those additional compliances will be a bit of a challenge, but there are technical solutions for all of these.
Absolutely, Dhruv, and the government is, of course, open to comments and feedback from the general public, from public stakeholders, so far as coming out with the final draft of these rules is concerned. On that note, thank you very much, ma'am, and Dhruv, for joining us here on this very, very crucial story and debate on the DPDP Act 2023 rules. Ladies and gentlemen, we're completely out of time on this edition of News Now. Hope you liked the show as much as we did putting it together for you. Goodbye, and thanks very much for staying with us.